We talked about in pretty good detail last time. So if you want to go back and look at our last spaces with the way this is going, and excuse me, we talked about in pretty good detail last time. So if you want to go back and look at our last spaces last time. So if you want to go back and look at our last spaces. Why are we saying this is a Sixth Amendment problem? Why are we saying it's a Fifth Amendment problem? What's going on with that? And we talked about how we would really be raising these issues full-throated if we were defending this case, unless the client kind of is okay with you not doing that under the circumstances. And you do have, we discussed this at the end of the last spaces, you have an unusual situation with this particular client, right, who's running for president again, and the election is now in 2 weeks and 2 days. And so with that kind of client, other considerations beyond strictly what the legal answers are sometimes will dictate what strategy you choose to pursue, what arguments you want to make to the court. So I think we concluded, King, is this the way you remember it, that probably that's what's going on. It's not that they don't see the issue the way we do. It's that they're deciding not to full-throatedly raise it because they're dealing with not just this legal case, but also with the fact that the client is a candidate for the highest office in the land.
There's that, but there's one other angle that I have mentioned before, and I'm coming around to the fact that they have made a call differently than the way we have discussed the strategy being. And that is, do they want this judge to decide the immunity issue based upon an evidentiary hearing?
The fact says she would choose to see them after a hearing.
Correct.
Right.
And which means witnesses would be called, they'd be examined and cross-examined by both sides. To some degree, the defense would have to show its cards as to how it might defend the case if it ever got to trial. Uh, and that's that's a tough nut to crack for any defense lawyer. As a defense lawyer, you want to see all of the prosecution's cards at a time, and you want to show him or
None of
her
yours.
none of yours.
Right.
and
Yeah. Yeah.
and
And it's
that's
very unusual to be having this kind of a hearing pre-trial, which is basically trying the case before you're trying the case.
um, highly unusual, and it goes against the grain of every criminal defense lawyer's training and instincts to think otherwise, and that may be driving in part how they're responding to this, because they are not doing anything uh, by raising the Sixth Amendment issue. Sixth Amendment says the defendant has a right to confront his accusers, which includes the right to cross-examine every witness who testifies against him. Uh, well, how do you cross-examine someone in court, in open court, before the trier of fact, the judge or the jury? And so, which is an evidentiary hearing. You put on witnesses and people cross them. If they're not going that route, the Sixth Amendment objection isn't as strong, because the remedy for a potential Sixth Amendment violation is to throw out the papers that got filed, put them under seal, and have an evidentiary hearing.
Right, exactly. Plus, they run into, and we explained this in depth last time, that the Sixth Amendment law has developed in such a way that at present there are no precedents from this circuit or the Supreme Court saying that the Sixth Amendment applies pre-trial, before the actual trial starts. Now, we concluded that we think that if put to that question, the Supreme Court will say that the former president has a Sixth Amendment right at this point in the proceedings on this immunity issue. but that hasn't been decided yet. So they're looking at a situation where they have a hostile judge who will make factual findings against them. The law is, even though they're going to be right about what they're arguing, the law is not developed. This judge has already said she doesn't see that there's a Sixth Amendment problem there because, in my opinion, because she just doesn't want to say that there is. She doesn't want to see a problem there, even though I think it's glaringly obvious. So there are a lot of reasons why it would be very difficult. It might go against them in the short term. So I can understand why they're choosing to make, as you say, sort of a different call, see it a different way. I still think I would not be doing what they're doing if it were me, and different lawyers can defend different ways. Not one way is not necessarily more right than another. But I would be worried about waiving that argument. And I also think this judge is going to make factual findings against them anyway, whether you have a hearing or whether you just go on the papers. And so I don't really see how you're losing anything. But all that being said, that is where it stood a couple of weeks ago when we talked about this. Smith had dumped his pleading on the public docket. He did that immediately, almost. The redacted version got released very promptly. The former president's lawyers had not asked for a stay of having the redacted version put on the public docket. I think Ship had raised this issue initially. I think they thought they'd have more time after the judge ruled on it to actually, lodge an appeal or ask for a stay before it hit the docket. But then it hit the docket, very fast. Judge Chutkin ruled on it, and the same day the clerk put it up on the docket. So, and they didn't get any advance notice of that. So, but what that left was that Smith's office had not yet filed, either under seal or unredacted, all of the backup evidence that they were using to support the pleading. And eventually they have produced 4 volumes of this evidence, and they filed it initially under seal, and they asked for the judge to let them file a redacted version on the public record. The former president's lawyers, in this instance, they opposed that and they asked for a stay. And I think, King, am I right that when we met last time, the the that was still pending with the court, or had that not happened yet by the time we talked last time? Do you remember?
That did not happen.
Okay.
Uh,
We talked about it, you, me, and Ship offline, but not on the spaces. Is that right?
that's right. And
Okay.
and just to be clear, the stay that the Trump team asked for, uh, they said let's and they got a 7-day stay,
Right.
telling
They
the
did
court
ask for it, and she did give them that. Yeah.
she gave him a 7-day stay, and the basis for the 7-day stay is we need that much time to decide what our litigation options are. And on day 7, they filed a motion to extend that stay until later in November, the to coincide with the date that Trump filed his papers in support of immunity. And let's just make it all public at the same time, because it's not fair to have a sequential prosecution. You do your stuff first, make it all public. Then we have an election. Then after the election, the court and the public will see what Trump's side says. That's not fair. You ought to do it at the same time. And so, please extend the stay uh, until the date that Trump's filing is due. And that it took the judge uh, what, less than a day to rule against him on that, and order that the full appendix of exhibits be unsealed,
And put on the
per
public docket, although
put
they
on the
were,
public
yeah.
docket, subject to the redactions that Smith was proposing.
Right.
And that was that therein, when he did that, I frankly was surprised.
Right. So we're going to get to that in a second. Let me pause here for a minute. So Ship is here. Hey, Ship, can you hear us?
Yes, finally. The
Okay.
co-host, I think, solved whatever technical problems I was having.
Okay. Good. Great. Um, so where we are is at this point is the judge let the government file the redacted version of these 4 volumes on the docket. That hit the docket last week. And it's 4 volumes, but, and that sounds like a lot of paper, and it is a lot of paper, but King, when you actually look at what's in those 4 volumes, what do you get?
You get 2/3 of it. I want to say the whole thing is over 1,000 pages. I forget the number, but it's many. But 2/3 of them are blank,
It's blank. They're redacted.
totally blank, not a word on them. Uh, and by all appearances, and we don't know that because he doesn't say why he's redacting things. But my best guess is that based on the absence of this type of evidence, there is no grand jury testimony made public, and likely some exhibits given to the grand jury, similarly not made public.
Because he cites to them in the pleading, but then you can't see them in the volumes of the backup evidence. So
And
they must be in there.
yeah, he also cites to FBI 302 memos of uh, interviews of witnesses, and none of them are made public in this filing.
Right. They're probably in there. They're just redacted. So of the over 1,000 pages or so, let's say 700, I'm just big picture ballparking these numbers, is redacted. You can't see what it is. It shows up on the docket as blank pages. What what did show up?
What did show up is, for the most part, things that either are in the public record, that is, uh, President Trump's tweets from back then, plus a a large volume of publicly available documents that either are in the public record already in through the January 6th congressional hearings, or things that you can look up and pick up off the internet.
Right. Okay. So, and then the Trump team, they did not try to appeal this, that she denied the request to extend the stay, and they she let this go on the docket, such as it is, basically a third of the information actually, and there's no appeal pending by the Trump team. So it looks to me like they're not going to appeal. Do we all agree on that, Ship King?
Yes.
Yes, I think they settled on that
A while
tactic
ago.
when they saw the original, when they saw their redactions more than anything. I think they settled on that tactic since so
Right.
much of it was going to be redacted, and what is not redacted is already in the public record, and most of the 165 pages are already in the public record. I think their objections were mostly for form, and so they could complain about it in the press.
Right.
But the, you know, as I said online, I suspect they have done extraordinary amount of polling as part of the campaign on this issue, and they probably see it as a net positive. Nobody cares anymore. The 165 page brief landed with a thud. Now
Yeah.
these indexes have landed with a thud, and I think they knew that was going to be the result.
Right. It's
But
too complex, arcane, indecipherable for most people, just
most of it,
at
and most of it's
all.
most
Yeah.
of it's already known. What is
Right.
there is already known, has already been publicized. And the people that care have already decided.
Right. Or people who still care and maybe haven't made up their mind. How many of them are actually going to go through this and figure this out? Like, not very
No,
many.
right. The people who are truly the people that are truly undecided still is a very small number, and they're going to care about the price of gasoline and whether or not Donald Trump's a bad guy.
Right.
But
Right.
on the bad guy issue, there we know that there were witnesses who appeared before the January 6th committee and additional witnesses who testified in the grand jury who were not friends of President Trump. And there's no telling how bad that testimony is to him.
Right.
And what surprised me was even though both sides briefed the issue in advance, and the briefing assumed that the grand jury stuff would be included in this released evidence, it wasn't. What
Right.
happened?
It's been
What
provided to
happened?
the judge, but
Yeah,
not to the public. Right.
and so what happened? Why did somebody at DOJ sit on Mr. Smith and say you can't do that? That's against our policy to basically open up everything before the grand jury, before a trial, so the whole world can see what went on at the grand jury?
I don't know, Ship. What do you think about that?
I think it was a consideration given to the idea that if we do this and Trump loses, we might very well lose this whole case to the Supreme Court on outrageous government misconduct.
Right.
That the jury pool in Washington, D.C. is so poisoned. I mean, how could you ever argue that the jury pool would not be poisoned in Washington, D.C. if you made all that testimony, which with all the Sixth Amendment issues that attend to it, all the Fifth Amendment issues that attend to it, if you just laid that all out like it was, an encyclopedia? I think at some point they realized that if we want to have a prosecution that has a chance of going forward to a determination on the merits, you know, we need to act like that's what we want, and we don't just want an election spoiler.
Right. I mean, it appears to me that they want both, but, okay. So, it,
I agree, Chip, that there are people within the DOJ who think like that, but I've seen no evidence that Mr. Smith
not in his office.
No, no,
it has.
I don't disagree, but Smith has among his team some career AUSAs.
Right.
These aren't just a bunch of political appointee partisans. They're people that have been there 10, 12, 15 years through multiple administrations.
And they know as well as we do, this is not the way we normally do things for good reasons. So, okay, so they're trying to salvage it for a trial later. They may or may not be able to do that if Trump loses the election, also. So, okay, and then on the other side, we think the Trump team is basically decided this stuff is in the public domain, most of it anyway. Let's just turn into the torpedo, deal with this evidence if we have to. Pretty much, Ship, your point is that the voting public is interested in other things anyway, like what's going on in the Middle East, what's going on at the border, what's going on in North Carolina and Tennessee, et cetera, what's going on in women's sports, et cetera, et cetera. And this is not at the top of the list, not to even mention how much groceries and gasoline are. So, um, the truth is also, don't we think that, the Court of Appeals was probably not going to be inclined to get involved anyway?
Well, probably, but I think if you were really playing to keep it out until the election, the briefing schedule would have at least bought you another couple of weeks before they
Yeah.
would have. And so you would have taken it right up until election day, but still it would have only been 2 or 3 weeks or 2 or 3 days rather than 3 weeks.
Yeah.
But I think as a practitioner, I would say that they made a decision. It was enough to simply make their objections, let the judge run right over the top of them, ignore their objections, ignore the Fifth and Sixth Amendment issues. They're preserved for appeal. We told her don't do it.
Right. She did it
She
anyway.
did it. Right.
And they did buy themselves 8 days by asking for the stay and then asking for the extension on the last day.
And I'm sure they were pulling the shit out of it during those 8 days.
Yeah, probably.
You know,
So, all right.
that's something I think I tweeted out is that is sort of the unique circumstance they have. You know, campaigns spend millions of dollars on polls on a daily. I mean, they're polling every night,
Right.
and so they had, 18 months ago they weren't doing that. They would have not had the ability to get immediate feedback from polling on a night after night after night basis to see if any of this, as it happened, moved the number. Because obviously it's all about the election. If he wins the election, it all goes away. If he loses the election, then he's got jeopardy. Um, so because we are in the last month before an election, they are polling nonstop. So it's not a big deal to add this issue to that polling. And if
Right.
they look
Which,
at it
yeah.
and it doesn't move anything, it's like, okay, we'll make our objections, but we'll just let it go.
Right. Yeah, that makes sense. All right. So the next thing in that case, unless I'm mistaken, is King, as you were alluding to, is the Trump filing, which is after the election. Am I right? On this issue, on this immunity issue.
That's right. Yeah,
So no hearings, no more rulings, presumably from Judge Chutkin. So this may be another factor, right? That case is going to go radio silent now, between now and the election, because it was the
Or,
Trump lawyers that asked for the their response date to be set after the election. Ship, what were you going to say?
yeah, I just didn't know if there were other matters on the scheduling order that still have to be
well, on
addressed.
the briefs, I
Yeah,
think are in on the motion to dismiss the superseding indictment.
on Fisher or
Yeah, on Fisher. Uh, there may be a reply brief due from Trump, but it would be due, I think, before the election. So we could have a decision on that motion
I'm
before
looking
the
at the
election.
order. I don't think so. I think the next date is the 7th, November 7th, which is the response to Smith's magnum opus, as you call it, King, on the immunity issue, and also the motion to renew. I think that's the next thing that's due on the 7th. I could
Does
be wrong about that,
does
but
that include the motion to dismiss the indictment? Because Trump had his brief filed, Smith responded to it,
right. You're talking
and
about the Fisher argument.
the Fisher argument,
Mm-hmm.
yeah,
Yeah. Yeah.
and uh, and I think Trump's reply brief is due maybe next week.
Yeah. I'll have to double check that. I don't have those dates being that early, but I can look and see. So, but I mean, how many people do we think are reading these pleadings other than lawyers?
On those, nobody, but
Right.
they might read the judge's opinion.
Right. If she were to rule on that before. But let me see if I can pull it up here while we're talking to get the exact dates on that. So, what's his case number? All right, here we go.
what are you suggesting she might rule on before the election?
Yeah, I don't think anything.
Uh, Fisher, the Fisher
Oh,
issue.
Fisher, possible. Yeah, but I think she'd have to. I think she'd have to set that for oral argument. I don't think she can just run that right into a written opinion.
Yeah, I'm looking for the minute order. Okay. Da, 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 da. Okay, she changed the dates on the immunity, but did she change the dates on the Fisher? Let's see. While I'm looking for that, Ship, were you going to talk to us on the call tonight about why you're going to be in and out, or was that just for me?
No, I can. Yesterday I flew back to Hawaii. I have a hearing tomorrow morning on a Hawaii case, so I start trial for 3 weeks next Monday. And between now and then, I have to file an appellate brief. So I probably will not be sticking around too much longer. But I
Right.
have a little work in front of me.
Yeah, sounds like. Your case in Hawaii is not a January 6th case, right?
No, it's a three-defendant fraud case that I've had. It was actually set for trial this week in August of 2023.
Wow.
So I think it's been pending a while. Tomorrow morning is the final pretrial conference, and jury selection is a week from tomorrow.
Okay. All right. So this looks like the right order. Let me see if it is. Yeah, this is they seem to be following it. Let's see. So the government filed its response to the Fisher argument on October 16th. And so the Trump team's reply on that is going to be due. Well, okay. So the defense requests for leave to file the motion based on that Smith isn't properly appointed is due on the 24th. Looks to me like, yeah, that's maybe the very next thing that's coming up. The government's opposition to that's due on the 31st and the defense reply on the 7th. So I don't think she's going to rule on that before the election. But where's her ruling on the, yeah, it's not coming to me right off the top here what the deadline is for.
I don't remember a separate deadline. We may just be working under the local rules.
Right. Yeah. So far they're following her order except she extended it. I'm looking at the earlier version, which wasn't extended yet. Yeah, okay. But yeah, they are going to brief this idea about whether Smith is not properly appointed between, well, the last pleading on that will be due 2 days after the election, so she's not going to rule on that ahead of time either. And let's see, the government just filed their response to the Fisher grounds on the 16th. So what's that, 4 days ago? So the Trump team will probably file their reply on that. What is it, a week, I think, for that ship? Is that right? Under the normal rule. So,
Correct.
yeah, so that would be the 21st. So that'll come, well, that'll be tomorrow. Yeah. So she could, King, you're right. In theory, she could rule on that before the election, the Fisher argument.
I don't think she'll rule in the Fisher argument, but I think she will issue a pro forma ruling on his authority to his capacity, because there's a D.C. Circuit case that will control that. But I think on the Fisher case, I just think she's got to schedule that for oral argument. I mean,
For hearing.
yeah,
Yeah.
got to
Yeah.
let the
But
parties plug that one out.
that'll at least be all briefed before the election. The other
Right.
two will not be.
She could set the hearing before the election. She could set the hearing in a week.
Yeah. Yeah. But I'm just saying the argument about Smith's capacity, whether he's properly appointed, the
Yeah.
final brief on that isn't due until 2 days after the election.
Oh, okay. So yeah.
Yeah. The only one she could conceivably rule on beforehand, if she set the hearing, or if she decides not to hold a hearing, is the Fisher argument. So,
The Fisher issue I find interesting in that, in my opinion, Smith has taken the Supreme Court decision in Fisher on how broad the that decision is. He's taken it to the outside edge, and maybe, under Trump's view, crossed over it. So
right. Yeah. Right. We talked about once we get the final briefings on all of that, we're going to break that down pleading by pleading so people can understand what the arguments are. And that would be especially helpful if she does decide to hold a hearing. Okay, so Ship, since you can't stay with us for the whole time tonight, let's switch over to Bannon. Did you see my tweet where I said I wanted to talk about Bannon tonight too?
No, but I'm pretty sure I know what the problem is there. Or
Yeah.
should go ahead and
Are we talking about the First Step Act?
yeah.
Yeah.
I mean, I'm pretty sure I know exactly what the problem is based on other cases. First Step
Right.
Act there've been some developments in the last 2 months 2 weeks to a month favorable to defendants. Bureau of Prisons has sorted out some of its policies. I don't think that's the Bannon issue. What I think the Bannon issue is a BOP policy only applies First Step Act credits once a month, the beginning of the month.
Well, there's
So
several issues there. So let me lay it out for people. So we hadn't originally planned to talk about this. It kind of just blew up on social media the last couple of days. So Steve Bannon himself and his daughter on X are claiming that the government is holding Bannon past what his release date would be under the First Step Act. Now, I looked at the Bureau of Prisons inmate locator today, and Bannon is set to be released on the 29th, which is, I guess, Tuesday a week. And so he's got another 9 days here to serve. The court sentenced him and also Peter Navarro. They had two different judges, but they got the same sentence. They both got 4 months to serve and no period of supervised release added at the end of that. So what supervised release is in the federal system is once you serve your prison term, then you are still under the supervision of the government for a period of time after you're released from prison. It's sort of like being probation, but it's on probation, but it's not probation. Probation is in lieu of your sentence, in a general sense. The supervised release comes after your sentence is ended. You've already finished serving it, but the government holds on to you in a probation type scenario. This was developed to try to keep people from reoffending, right? It's trying to get people to go back into the community and not go back to a life of crime, et cetera. You know, they have an officer who's responsible for them. They have to work, they have to do certain things. They're still under a lot of conditions. If they violate those conditions, they can be locked up for the violations, even if they've served 100% of their sentence already. So, but the idea is that to kind of help people reintegrate back into the community and not reoffend. Now, I don't know whether you agree with that or don't agree with it. I'm not sure whether I agree with it or don't agree with it, but that's what the law currently is. So, but neither Navarro nor Bannon got, as part of their sentence, they did not get supervised release. They got 4 months to serve. Bannon got a fine in addition to that. And so his release date on the 4 months is October 29th. Now, under the normal, forget about the First Step Act for a minute, but under normal federal rules, statutes, you get good time credits. There's no parole in the federal system. There used to be, but there isn't
no,
now.
no, 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 no. No good time for a sentence of less than 12 months.
Oh, I'm getting there. I'm getting there. So, under the normal rules, you get good time, but only if your sentence is more than a year. So, you will sometimes see defense lawyers ask a judge to sentence the defendant to a year and a day, because as long as it's more than a year, even if it's only 1 day more, then you're eligible for good time credits. Okay, but those are the normal good time credits. The First Step Act is different than that. So the First Step Act is an act that was signed into law by President Trump, and it allows for good time credits in a different way. But interestingly, the statute says that they can be used, the the numbers of the days are different, but also they are used to let the person go sooner into either a halfway house situation, which the statutes and the regs call pre-release custody status, or they let you go earlier into supervised release. Well, Bannon is not getting supervised release because the judge didn't make that part of his sentence, nor is he going to be going into the halfway house scenario because since he only got 4 months to serve, the Bureau of Prisons doesn't process people with sentences that are that short into the halfway house situation. They just let them serve their sentence and then they release them, and then they either have supervised release or they don't, depending upon what the judge sentenced them to. So Bannon's not going to do halfway house, and he doesn't have supervised release. So he's not eligible for the normal good time credits because his sentence was less than a year. And although technically, I guess he can earn the good time credits under the First Step Act, he can't use them because he's not moving from an in custody incarcerated status to either a halfway house or supervised release. And that's by the statute. The statute says it has to be one of those two things, that's where those good time credits are used for. So there is some case law, pretty recent, 2023, one district court case, I think New Hampshire, where a judge said, well, maybe you could construe a request from a defendant to use their credits to say that they want to be resentenced, and you go back, you the judge, if you find compelling circumstances under a different statute, you can resentence the guy and give him some supervised release, and then he could use the good time credits to move from an in custody status to supervised release earlier than he would have otherwise been moved to supervised release. So both Peter Navarro's lawyers, who I happen to know very well, and also Bannon's lawyers, who I know but not as well, they have asked the two judges to do just that. Now, Navarro's lawyer judge said, no, I'm not doing that. In Bannon's case, Judge Nichols has not acted on this. He has not ruled on it. Nick Bannon's lawyers made this argument for him back in, let me look at my notes. At the end of August, they filed some supplemental authority last week because they were asking for either bail for Bannon, for reasons we'll get to here in a second, basically because his case is still pending in the Court of Appeals, or to be put on supervised release so he can use his good time credits. And basically Judge Nichols hasn't ruled on either of those. So Ship, what's your two questions for you. What are you talking about with the monthly application? And also, is there any cases that are newer than that New Hampshire case that you know of?
Not that I know, but the biggest change in the Bureau of Prisons policy, and I thought I didn't realize this argument that you're talking about with Bannon. I thought the problem with Bannon was because they only apply the good time credit once a month, that he technically is going to be eligible for release by application of good time credit prior to the end of the month, but they're telling him we're not going to give you the credit until the end of the month. So you got to stick around to the end of the month to get the credit that then makes you eligible to leave a week earlier. And this has been a problem in the way the Bureau of Prisons has interpreted the statute. A big issue that just got resolved actually in favor of defendants is the statute is written in such a way, and I haven't studied the statutory language, but I've talked to a couple other lawyers who have about this. The statute's written in such a way that it directs the Bureau of Prisons to do a full sentence calculation of the good time credits that a defendant can earn once they enter the program. They call it programming. You sign up. Now, in a lot of the facilities, people are going on a waiting list for First Step Act because it's all computer-based modules. There's only so many computers, and everybody's standing in line to use them. So there's a waiting time before you can even start to do the computer modules. But under the policy, you begin to earn credit the day you sign up, even if you can't actually start.
Yeah, and what you get, let me look at the statute here, is you get 10 days of time credits for every 30 days of participation in the recidivism reduction programming. So yeah, so if they've now said, well, that 30 days starts the day you sign up, it's not your fault that the program is, oversubscribed, basically.
Right.
That's fine. So Bannon would have been earning the credits, assuming he signed up for these programs, at when his sentence started. Now, when you
Right.
first go into Bureau of Prisons, you're in isolation. I don't know whether you could sign up during that period of time. Blah blah blah. But with a 4-month sentence, he should have at some point been able to sign up for these programs, right?
Right, but
So,
he's not. But he's not going to get his. Under the way the Bureau of Prisons was doing it, your credits were always applied retroactive. In other words,
right at the
you get to
end,
the end of the month, and then they give you back 10 days. So
right?
now, so he's there such a short period of time, he's going to overserve before he gets that last credit that would have, in essence, made him eligible for release 7 days earlier.
He's never going to get it though, because he
Right.
doesn't, which for a different reason, right? For the reason that I laid out. Even
Yeah.
if
Okay.
Bureau of Prison fixes the retroactivity problem, he
Right.
doesn't
But
have the kind of sentence that he can use it for.
right, and I haven't had to confront that problem yet. But the
Yeah.
other one that's interesting, and you got to listen to the math here because it's going to shock you. Say a defendant gets a 60-month sentence. Technically, under the statute, under the First Step Act, he can conceivably get 20 months credit, right? 10 days.
20 days. Mm-hmm.
10 days credit for every 20 days or 30 days of participation.
Right. So he
So
get 20 days off
conceivably, he can get
the
20
6
months
months.
off. Now,
20 days, not months.
off the entire sentence of 60 months.
Oh, you said 60 days. You meant
I'm
60
sorry,
months?
60
Yeah.
months. So
Yeah.
5 years of
Right.
typical
Okay.
sentence.
I'm with you now.
Okay,
So 5
now,
years. Yep.
right. The way the statute reads, my understanding is the Bureau of Prisons is supposed to do that calculation as soon as the person begins programming. As kind of here's the carrot out in front of you. If you follow this program, we're going to move your release date all the way back 20 months rather than 60 months. Okay. Now, from that point, you then take the good time off. Then you maybe take off RDAP. The
All right.
person has
RDAP
earned
is,
a
so people
drug,
know,
drug treatment program.
right.
If
You
you
can get
have
up to a year off your sentence for drug rehab. Right.
all right. So when you stack these things up, you've given the person credit for 60 months of participation in the program. They're only going to be there for 15 months.
If you add all of that, layer
And
all those things on top of each other.
when you chop all of those months off with credits, they don't even serve a third or a quarter of their sentence, but they get credit for the First Step Act as if they did, because because the statute reads that they're supposed to apply them and give a projected release date on the date they begin programming. It's sort of like a good faith assumption that you're going to continue to, and if you stay in the program,
Yeah.
that never changes. There are there are 2 defendants that I know of that were given 54 months. They will serve less than 18.
Wow.
And then they're getting released. Because one of those other things that we've talked about, and you're aware of, is the halfway house. I'm
Right.
now seeing programming for First Step Act. So if you're in the First Step Act, you don't have a violent offense, you participate in like Unicor in your facility, which is a company that the government runs that builds office equipment and office supplies and stuff like that. Unicor, they have factories in various Bureau of Prisons facilities. So if you do all of those things and you're going to earn maximum First Step Act credit over the course of your sentence, then they're getting 12 months halfway house, not 6.
Wow. Okay. So the standard Bureau of Prisons thing is you get halfway house at the last 6 months of whatever your period of incarceration is going to be. That's the working rule that defense lawyers use.
That applies to everybody. But if you're
Right.
First Step Act compliant, you get 12 months.
Right. Now, we should point out for people, it's not like they're going to let murderers and rapists take advantage of any of these things. They're not. The statute has a bunch of disqualifying offenses in it. So it
Right.
does also depend on what you were convicted of.
Violent crimes, a crime of violence, it is
Yeah.
disqualifier from First Step
Right.
participation. And I
Right.
think a second drug trafficking crime, I think, is also a disqualifier.
Right. Child abuse, all the really
Right.
bad stuff, they're not going to qualify for any of this.
But it is. I've got one just got his calculation on a 42-month sentence is going to do 9 months.
Wow, interesting.
It's crazy. The numbers are absolutely crazy.
The First Step Act also changed the way the normal good time credits are calculated. So it used to be you got 54 days off for every year that you served. That was the maximum good time credits you could get. And now instead, they're basically saying the number of good time credit days that you can get off is calculated based on the sentence you received, right?
Right.
So if you got a 10-year sentence, you can get 540 days off. And it's what you're saying, Ship. It sort of like assumes that you're going to
There the
uh,
whole time. Right.
be good, on good behavior the whole time. Now, if you're not on good behavior, obviously that's going to create problems and they're going to redo the calculation. But I do think that it's a good incentive for people to stay on the straight and narrow while they are incarcerated so they don't
And
lose those days.
and to stay in the program.
Right,
The
exactly.
First Step Act is maybe, I don't know if we ever explained that. The First Step Act is anti-recidivism.
Right.
It's mostly for first-time offenders to say, here's the bad choices you made along the line that got you.
Where you
I've
are
got
now.
yeah, and if you're a first-time offender, here's the ways you avoid antisocial behavior that could lead you down a criminal life, or it's a very much a psychology-based approach to minimize reoffending, and they've loaded it up with carrots to keep people in the program. And the biggest carrot is, if you want to go home sooner, stay in this program and pay attention.
Right. And don't create problems while you're here.
Right.
And I think that these are good things in general. There's a reason this statute, the First Step Act, was a bipartisan supported effort because, we do want to discourage people from saying, well, I have these federal offenses on my record now, because once they get out of jail, that's going to keep them from getting a lot of jobs. It really limits people's opportunities, and okay, appropriately so sometimes, but not appropriately so in other situations, especially for nonviolent offenses. So it's trying to make sure that the incarceration process itself doesn't create more problems as opposed to solving problems. So, but bringing it back around to Bannon's case, I don't think he may be eligible to earn these good time credits under the First Step Act. He's not eligible for the normal ones because his sentence is too short. He is, I think, eligible to earn the good time credits, but he can't use them because he's not being released to either a halfway house or unsupervised release. So his counsel have asked for his sentence to be redone, basically, to take a few days off the 4 months and instead give him, I think they asked for a year of supervised release. And then that way he can use the good time credits to get onto supervised release earlier. So that would have shortened his sentence, especially if they'd done that back in August. But Nichols has just sat on it. And there's some other procedural hurdles there, like the judge has to make findings that there's a compelling and extraordinarily good reason to be resentencing him. So maybe Nichols isn't sure that applies. But I do have to say that I think as a technical matter, Bannon is not being held illegally past what he's eligible for, because technically, even though he's eligible for those credits, he can't use them. Chip, what do you think?
No, I hadn't looked at that issue, so I think you are probably right. It might be something that is subject to, the Bureau of Prisons could issue a policy modification or not the Bureau of Prisons, the Attorney General could issue a policy modification that says that, as a regulation, we're going to make.
I don't know if they can, because that language is in the statute.
Well, they're not. They would not be violating the statute. They would be adding another basis for for early release to the statute. They wouldn't be taking something away. They would just be adding to it as a regulatory policy.
What would you propose? How would that work?
They could make it subject to, anybody. You could apply First Step Act to your custodial sentence. Anybody who's sentenced less than a year.
Oh, okay. But the thing is, the statute itself says that the credits have to be used toward the purpose of releasing you to either supervised release or the halfway house scenario. It's literally in the statute. I
Well,
don't,
I understand that. I'm not sure that precludes the Attorney General from issuing a regulation to the Bureau of Prisons that says, and in addition, we recognize the utility of applying First Act credits to the end of custodial sentences of less than 1 year. So if you earn them, you have a way to use them. It's not violating the statute. It's adding another utility to the First Step Act. Violating the statute would be, well, we've decided you can't use them for supervised release if ABC.
okay, but the language says, time credits under this section shall be applied toward time in pre-release custody, that's the halfway house, or supervised release, period. The director of the Bureau of Prisons shall transfer eligible prisoners into pre-release custody or supervised release. I really don't think that DOJ could do anything about this without an amendment to the statute.
I think your argument would be much stronger if the statute said can only be used for those two things. In other words, it's excluded other alternatives.
Ship, you're sounding like a Democrat.
Yeah, I mean, they could try that,
Well,
and I don't know who would complain about it if they did. But
That's
the way I
the
read
point.
this language,
That's the point.
I don't see
If the Attorney General issues a regulation, Congress can always come back around and say, no, we don't want that.
That's not what we meant, right? Well, it says the director of the Bureau of Prisons has to transfer them into either pre-release custody or supervised release. The way they could get around it would be if the Bureau of Prisons changed its regs for short-term people with short sentences like Navarro and Bannon got, and said for First Step Act guys, because they're almost all men, we will say they can go into the halfway house scenario. Right?
Yeah, they would make them eligible for halfway house.
Right. Yes. Then they could do it
1
without,
month or
yes,
2 months.
Exactly. Then they could do it and not violate this statute. But unfortunately, that's not their policy. And so Bannon he's betwixt and between. He's not eligible for this. And so even though technically he's got the credits, he can't use them. So his lawyers, I think, have done all they could do to try to get him relief on that front. But, Bureau of Prisons, I think, thinks their hands are tied. So the other thing he's asked for, though, from Judge Nichols is bail. So when the Court of Appeals affirmed his conviction back in May, the government moved right away to lift the stay that was in place pending his appeal. And Nichols lifted the stay and gave Bannon a report date. And then Bannon's lawyers promptly sought bail from both the circuit and the Supremes. This was back in June. And neither one of those courts were interested in giving him bail. And then Bannon filed his petition for rehearing in July. The court originally ruled in May, but they gave him an extension to file his petition for rehearing en banc. He filed that in July. And he filed based on two arguments. One is that he was deprived of his ability to rely on the advice of counsel because he is saying that he didn't show up to the congressional subpoena based on the advice that the lawyer gave him, and that how could he therefore be willfully in contempt and willfully, ignoring the subpoena. So that was one argument. The other argument that they raised on his behalf was that the committee the J6 committee was not properly constituted. Okay, so on these two issues, there is a circuit precedent directly on point, unfortunately, about this willfulness business for contempt of Congress. The name of this case is Licavoli, which says you don't have a right to rely on advice of counsel in this situation. And so the panel that decided his case cannot overrule the circuit as a whole. It's only 3 judges. They can't overrule an existing precedent themselves. So, of course, he was doomed to lose in the Court of Appeals on that ground, at least initially, which he did. And now his lawyers are asking the whole court to reverse Licavoli. And they did that, as I say, on July 15th. They also raised the second argument about the committee. So interestingly, the court, about a week later, on July 22nd, issued an order saying that they wanted the government to respond to the petition for rehearing, but only on the issue of whether or not they should overrule Licavoli. They're not interested in the issue about the January 6th committee being not properly constituted. So the government filed their response on July 31st. And so far, the circuit has not ruled on this. Now, for those of you who are not appellate practitioners, this is a really long period of time for the circuit not to have ruled on a petition for rehearing. Normally, they reject those, well, all of them, 99.9% of them, maybe not quite that many, but pretty close, within 3 weeks. And so once you get past 3 weeks, you're either getting granted, they're going to hear it, or they're not going to hear it, but one of the judges is unhappy about that they're not going to hear it, and they're writing a dissent. And so the court is giving that judge or judges time to write an opinion. So at this point, I think it's completely clear. Bill, Ship, I'm sorry you have to go. Thanks for joining as far as you could. At this point, I think it's completely clear that the circuit is either going to take up Bannon's argument that Licavoli should be overruled, or they're not going to, but a handful of the judges on the court are not happy with that, and they're writing a dissent. And once that comes out, obviously if they agree to take it, then it'll get briefed again to the whole court, and they will hear it. But if they're not going to take it, then at that point, Bannon would have the opportunity to take the case to the Supreme Court. So, Steve happens to have written an article about this Licavoli case, and so I thought we might ask him to weigh in here. And King, I'm throw the floor open to you too. Have you read any of these arguments about this willfulness?
Some time ago, yes,
Yes, we talked about it before, I think. Yeah.
and we did, and that what vintage is the Licavoli case?
It's
When was it?
1961.
Okay, that's what I thought. It's old law, and Bannon says no longer good law.
Right. And Bannon's got a good argument. The
On this point.
yeah. Let me walk through this. I wrote an article 2.5 years ago on this precise issue. And the starting point is the contempt statute itself, which Bannon was found to have violated. And it punishes any person who is summoned as a witness by Congress and willfully makes default, or who appears and refuses to answer a question. So the key word there is willfully. Now, Licavoli ruled in 1961 that under the statute, advice of counsel cannot immunize a deliberate intentional failure to appear pursuant to a lawful subpoena lawfully issued and served. So that is what the judges have relied on in saying, oh, Bannon, no advice of counsel defense for you. But
So he tried to raise this with the jury, and the district judge, Judge Nichols, who I think doesn't like it, but is absolutely bound by Licavoli, Judge Nichols, he did not have a choice. So he couldn't let Bannon argue that to the jury. Well, the lawyer told me I didn't have to show up.
Right. But the issue arises because of a subsequent decision by the Supreme Court. In 1998, the Supreme Court ruled that to establish a willful crime, the government must prove that the defendant acted with knowledge that his conduct was unlawful, which therefore would make an advice of counsel defense admissible to show that the defendant didn't know that because his lawyer, upon whom he relied, had told him,
Reasonably.
right, had told him that no, it's not a lawful subpoena. And when you say that the judges are bound by the 1961 DC Circuit decision, that's generally true unless there has been an intervening Supreme Court decision that causes that to no longer be good law. And the basic argument here is that the 1998 Supreme Court decision says, wait a minute, if it's going to be willful, it can't, it can't apply here, and therefore Licavoli is no longer good law. Now,
But you often see the case where even though lawyers are reading the Supreme Court's more recent cases and they can see for themselves that the more recent case has undermined an earlier case, if the Supreme Court sometimes hasn't literally said, oh, and by the way, we're overruling blah, blah, blah case, judges sometimes will become very conservative, especially on the Court of Appeals, and say, not conservative in a political way, but conservative in a, proactive versus more reticent kind of way, they will say, well, that case hasn't actually been overruled. It's just the theory of it's been undermined. And so, but we can't overrule that case. The higher court has to do that. And as a practitioner, I always thought that this was basically an exercise in cowardice because lawyers have to advise their clients as to what they can and cannot do lawfully under the existing law, taking into account everything that the Supreme Court has said. And so if lawyers have an obligation to do that and have to advise their client in that manner, what in the fuck is the problem that the Court of Appeals cannot do the same and say, well, obviously the Supreme Court's precedent of XYZ undermines our opinion in ABC, and therefore that case is no longer good law, even though the Supreme Court didn't literally tell us that. But this is the situation with the courts of appeals, is they often just will not do it. They need the Supreme Court to tell them. So this is the situation here. The Supreme Court's interpretation of willfulness in criminal statutes does not, over the last 40 years, does not support Licavoli any longer. But, and this is not a criticism of Judge Nichols, because really he probably can't do anything about it. But the Court of Appeals, the panel that heard Bannon's case earlier this year, they certainly could have said, we don't think Licavoli is any good any longer, and we're not going to say that it is, because the Supreme Court cases go the other way now. But they just won't do it. So now Bannon is asking the whole court to do it. The whole court could, in theory, have enough cojones to do this, but I'm not betting on that either. I think it's more likely that a few of the judges are going to dissent and the court as a whole is still going to uphold Licavoli, and then Bannon will have to take that case to the Supremes.
I agree with that. Here's the practical problem. When you're dealing with a contempt statute, the whole point is that in order, when somebody before a court is threatened with contempt, advice of counsel is a defense that would let them escape from the hard choice of being tossed in jail for contempt or not. Whereas in other situations, if a defendant wants to challenge it and appeal a ruling, you basically have to run the risk that if you're wrong, if your appeal is wrong, then you end up in contempt and you've got to serve your sentence. And this actually, while it doesn't sound sort of in the abstract fair, it actually makes sense in a lot of practical situations, including here, if you take a look at the contempt of Congress statute that all of this is relying on, because the contempt of Congress statute deals with two situations. The first, with which we've been discussing, is a subpoena to someone to come and testify before Congress. But the second is while you're actually giving testimony in front of the congressional committee,
Right.
and the committee asks you a question, and you decide,
say, I'm not answering
right,
that.
you just, you decide that you've got, or your lawyer decides that you've got an objection to it, that it's not relevant, that it's this, it's that, it's the other thing. And as a practical matter, I mean, this arises in trials all the time with regular courts. When you're in trial before a court, the judge has to rule on whether or not you've got to answer certain questions. And the rule there is very clear that if you don't answer, you can be found in contempt, and you can appeal later on. And if your appeal is upheld, then the contempt will be purged, and you'll be, your record will be unblemished. But if you're wrong, then you end up convicted of contempt, and you've got to serve the sentence. And it's driven by practical considerations that during the course of trial, the judge has got to be the umpire. It's like a sports game, like a football game or a baseball game. The umpire's ruling, to some extent, has to be final, or the referee's ruling has to be final in order to make the thing work right. Maybe subject to a limited instant replay appeal, but not to 3 weeks or 3 months or a year later, like with the judicial process, where the reviewing committee comes back and says, no, we disagree with you. It's got to be final. So here the same statute says both things, that if you fail to appear or if you fail to answer a question, you can be held in contempt. And in terms of refusing to answer a question, which is one part of the statute, I think it's pretty clear under the law, and it makes sense as a matter of policy, that you've got to, you've basically got to bet your liberty. You've got to bet the contempt.
You have to pick a lane.
Right. You got to pick a lane. Are you going to answer or not? But there is no need for that with respect to when you get the subpoena in the first place. What normal people do when they get a subpoena from a court or this or some other an administrative body or Congress is they go to see a lawyer and say, what do I have to do? And if the lawyer says, well, this subpoena is unlawfully issued, you don't have to comply with it, then people follow that advice. And the general view is that people shouldn't have to go to jail because the lawyer gave them bad advice, hence the advice of counsel defense. But here, the courts have said Steve Bannon can't raise that defense. Now,
so what you're saying is that it might make more sense, Licavoli, in the situation where it's on a question by question basis.
Yes.
But it doesn't make any sense when you're talking about he didn't show up at all, and he told them the reason I'm not is because my lawyer told me I don't have to.
And on the particular facts here, there would still be an argument that Bannon should be found in contempt because he just basically said, I'm not going to show up, as opposed to, well, I'll show up, but there's a variety of things you can't answer. You can't ask me because they're privileged. He was relying on executive privilege, but it was clear from the start that not all the questions that would potentially be asked of him would touch on things where he had a legitimate claim of privilege. And yet he basically gave the committee the back of his hand. So even if an advice of counsel defense was permitted here, which it hasn't been at all, the prosecution may be able to overcome it. The issue here is whether in concept it's permissible at all.
Right. Now, he was also relying on the opinion by, wasn't it the Office of Legal Counsel, that certain advisors, close advisors of the president, could simply refuse, even if there was not executive privilege on a question by question basis. And that hasn't really ever been tested. It's simply an opinion. But it makes sense in a certain way that people who are very close to the president can't be hauled in front of the judge, can't be hauled in front of the Congress to say, well, what's the president telling you? And I have always thought that if we're going to have any sense at all about the way we do this, that has to be the case. It can't be the case that the first lady and the vice president and the president's close in advisors, his chief of staff, so on and so forth, can be hauled in front of bodies, judicial or legislative or administrative, and forced to say things that the president, him or herself, could keep private or privileged or would be executive privilege. Like you can't just go through the back door, what you can't do through the front
Right.
door. But no court has ever said that there is sort of this zone of protection around the president. But I think if push ever comes to shove, the Supreme Court probably is going to have to create that rule because otherwise, I don't see how the office of the president can function. And we do that in other ways. The Congress has recognized that in other scenarios. Like, and King, I'm going to ask you if you know of anything else like this. But for instance, the Hatch Act, which prohibits politicking by government officials, doesn't apply to the president. It doesn't apply to the vice president, right? It's the same kind of idea that those offices are different and unique, and in order for them to function, some of the normal rules that we apply to everyone else can't apply to the president. King, you want to weigh in here?
It's analogous to the Supreme Court's evaluation and analysis of presidential immunity.
Yes.
It involved the issue of how far Congress can go is a separation of powers issue, and it's fundamental to the way our Constitution was set up to create an executive branch that was separate from both the judicial and the legislative branches. And so in the big picture, the question is, how far can Congress go to compel high up members of the executive branch, the president and his chief advisors, to come to Congress pursuant to a subpoena and open up everything and tell all? Uh,
Especially because people are always shocked at this. The Congress does not recognize any privilege in front of it except constitutional privileges. They have never agreed that your other privileges, what lawyers call common law privileges, like attorney client privilege, like husband and wife privilege, um, they have never recognized doctor patient. They don't recognize those as applying to the Congress. So the Congress's lawyers think that the only privileges that you could assert when you're testifying in front of them are constitutional ones. So, you're limited already to what you can do to defend yourself. And so to go beyond that and say, well, oh, and also, by the way, the president can't say, and his close advisors can't say, we're asserting executive privilege, that's probably a bridge too far.
but in historically, this is an issue. This battle back and forth between the Congress and the president and president's advisors has been going on for decades and even longer,
Right.
and it doesn't go to court. It's generally worked out. Both sides realize that each side has strong arguments, and they can it's kind of fought as if it were a political battle, not
Right.
a legal one.
Right.
And suddenly that's changed.
Right. We all know why that is. So at this point, we'll see what the circuit's going to do. But in the meantime, Bannon's lawyers have been trying to get bail from Judge Nichols on the grounds that the circuit is certainly going to either grant the petition for rehearing or is going to deny it, but some of the judges are going to dissent. And the reason that's important for bail is because if there's a change in circumstances and you, as someone who's been convicted, if you can show that there's a substantial issue at stake in your case that could go in your favor on appeal, then you're entitled to ask for bail. That's why Bannon's lawyers asked for bail from the Supreme Court back in June, because they think this issue about the willfulness for contempt of Congress is something that the Supreme Court will probably be interested in. And because it is the contempt of Congress statute, they're probably right. There are lots and lots and lots of criminal cases that the Supreme Court takes a pass on, that they're not interested in taking up every single term. But things that kind of only happen in DC, as we saw with the immunity cases or the Fisher opinion, things that really only are going to happen in the capital city, the Supreme Court is more likely to take. And contempt of Congress is one of those things. So I think that there's a good chance that the Supremes will take this case also. Now, in the meantime, Bannon will have served his entire sentence because he's going to get released next week. So,
I think that I agree that the Supreme Court is more likely to take it precisely because of what King said, because it goes to the separation of powers.
yeah,
And if you uphold what happened here, it basically puts enormous pressure on people who get a subpoena from Congress to appear and to start answering questions. And, let's be frank. I mean, Steve Bannon is not the best poster boy for raising this issue because he's educated, he's smart, he's brash, and he was very clear that he was going to tell Congress, that they could take a hike. But the issue could arise equally if you Congress subpoenas some 20-something
two-year-old
aide,
intern,
right, or
yeah.
intern, someone, I don't mean to pick on, but Hope Hicks, some very attractive young person who's clearly operating in good faith and is close to the president, and they want to find out what did the president say. And then the question becomes, and this is the way it's got to be addressed, is, what would we say if Hope Hicks got a subpoena like this and went to an attorney and the attorney told her, Hope, you can ignore the subpoena? Are we going to say that she then, gets criminally convicted because she couldn't rely on the advice of her counsel?
Right. So, so we'll see. But I'm not sure why Nichols has sat on the motion for the release. Maybe he's just not sure enough. He told, and Bannon's lawyers reflected this in their pleadings, he told them, because he held a hearing on this, which he didn't have to do, I will say, in his defense. But he told them from the bench, well, it's not like any of the judges on the courts of appeals have expressed reservations about this, about Licavoli being bad law. And so Bannon's lawyers have been filing these papers, and they filed a supplement this week saying, yeah, but Judge Walker ultimately did come out and say he was concerned. Now, Walker's on the Court of Appeals. Judge Walker did come out and say he was concerned because he dissented when the circuit denied Bannon bail. And so Walker said exactly the kind of thing that Nichols was looking for, which is, well, I'm not comfortable with Licavoli. I think that Licavoli might be wrongly decided. And so they've been trying to convince Nichols that because the circuit has held the case for so long, that means they're either going to take it or there's going to be a dissent. And therefore, that's enough for Nichols to say it's a substantial issue and Bannon should get bail. Did you follow all that, King?
I did, but just as an aside, a lot of our listeners are having problems with the audio going in and out.
Ah,
So I'm hearing you perfectly. but not everybody is in the same boat.
Yeah, that may be the speaker here that's picking me up. I have it turned away from me so Steve could talk. So, all right, let me. Um, Sometimes,
Uh,
you know what's weird is it also works better when I have the phone plugged in, like charging.
yeah,
It
I don't think
doesn't.
it's on your end because
Ah,
you sound fine for me.
yeah. And
I,
I
th- I,
will
th-
tell people we had this problem one time before where the audio was cutting in and out a lot for listeners, but Ship and King and I could all hear one another clearly. And then the recording, which of course gets released later, was perfectly clear. So it may be that it's not on the recording side, but it's on the transmission side. So there's nothing I can do about that, but I apologize anyway.
yeah, it's. I'm apparently cutting in and out also to
Okay.
some people, not everybody, but
Yeah.
to some people.
Okay, so just so people know, I don't think that's anything we can control on our end, so I'm sorry. Um, okay, so King, what do you make of this? I have never seen this kind of a pleading where the lawyers are telling the district judge, well, the circuit's had this case for so long, that means that there's a substantial issue. Steve's just laughing because, I mean, I've never seen this kind of pleading before.
I have never seen it either.
I mean, it's good
Yeah,
advocacy, good for them, right?
it is good. I've had a case or two where an appellate court sat on something uh, to to what I thought was an inordinately long period of time. Uh, I think once or twice a lawyer might have written a letter just
Right,
to tickle them a little bit to
right.
get their attention, but nothing like this.
Right. It's an unusual argument, but it's perfectly good argument. They're not wrong that 100% of the time, if the circuit has held the petition this long, there's only two choices, either of which, this is their point, either of which would be enough, and the government conceded this in their brief, would be enough to say that at least there's a substantial question in his case. And if there's a substantial question, then the judge should consider giving him bail. So, but that brings me back around to if Nichols doesn't give him bail by the 29th, it's just not going to make any difference anyway because he's going to get released on the 29th. So at this point, it may be that everybody's like, well, whatever, you've already served your term. Which brings
That
me,
I would strongly argue the other side because they that's the ultimate middle finger,
yeah, right.
and I don't think the court would do that.
Right. So it's a puzzle. They probably are surprised too. That's why they filed this supplement this week, why Nichols is sitting on it. Another interesting aspect of that is that the supervised release would allow him to be released earlier using, as we discussed, his First Step Act credits. Um, but then he'd be on supervised release. So if Nichols gives him a new sentence and adds a year of supervised release, at this point, I don't know why you would want that. I mean, as a defense practitioner, often a client would be like, I'll just do my time if it's short and get it over with, rather than continuing to be answerable to these idiots, right? Have a probation officer making you do stuff. You have to call in, you have to report, you have to do all, you're at their beck and call. And if they're not happy, they can file an order with the court saying you're out of compliance, and then you could get locked up for that. And so for some people, it's just better not to be under supervision and just get the.
Bannon has other pending criminal charges, doesn't he? Doesn't he have charges up in New York?
I think he does have new charges up in New York.
So I
Yeah.
think he has the state analog of the federal charges that were dropped against him regarding.
Yes. That charity.
Yeah. Okay.
Mm-hmm.
So
Right.
I agree with everything you've said. I'm just saying that in his case, the calculus may be different to the extent that even if he gets fully released from federal supervision, he may have state supervision, to contend
To
with,
deal with after.
in which event he may, the feeling may be, I'd rather escape another 9 days in a federal correctional institution
If he's going to be on supervision
if I'm going
already
to be under
anyway.
supervision anyways.
Yeah. Plus, Bannon's not the kind of client who's going to violate supervision, right? He's going to call every Monday when he's supposed to. He's going to be working. He's going to, he's going to do all the stuff. So, no real big risk of violation of supervision. I mean, most defense lawyers have had clients where, because of their mental health or because of their addiction issues or because of their personality disorder or because of their family circumstances, it's easier for them to do time locked up than it is to comply with all the stuff their probation officer wants them to do. And that's just messing up their life, being on probation and getting them into more trouble. And they're just better off doing the weekends or doing 2 weeks or a month or whatever it is. But Bannon is almost certainly not in that category. He would, I think, be able to comply with, he might not like it, but he'd be able to comply with the requirements. So, okay. Well, then the other thing that has happened this week, King, turning back to the former president's cases, is that his lawyers have gone back to the Second Circuit. Did you see this? On this removal issue in New York. Did you read that?
I did not read that. No.
Yeah, I haven't read the filing. It's 100 pages long. But basically, they are trying to, as we talked about before, so I'll just recap for people quickly. The former president asked the federal court to take the state criminal case into federal court on a removal, just like the removal that is going on in Georgia, that Mark Meadows is taking the lead on that, and Jeff Clark. And so the first time, the district judge, the federal judge, said, King, you want to remind us? No removal. Why?
No removal for a variety of issues, mainly including no immunity, because everything he did was private conduct, having nothing to do with his official acts as president, and no
Preemption.
preemption of the state law by the federal election laws.
So the first is probably right? Although it may not entirely be, because this is the case, remember, that has to do with the payments to Stormy Daniels and whether that's properly recorded on the books and records of the Trump organization and blah, blah, blah.
It's right to a degree, but there's a section of the Supreme Court's immunity decision that basically said, not only do you have immunity for official acts or presumptive immunity, but you can't use evidence of those immune acts to convict you for
Something else.
something that you
Yeah.
don't have immunity for.
Right. And when we looked at this before, we thought for sure the state of New York used some things that were or should be properly seen as immune, but they could probably plead around that if they had to reindict it, right?
They could,
But
but
they didn't.
over Trump's objection,
Yeah.
they put that conduct and that evidence
Yeah.
before the jury.
Right.
So,
Exactly.
so Trump's argument is the jury heard about my conduct that is absolutely immune, and Supreme Court says you cannot use that evidence against me,
And
and
yet you
that's
did
and
anyway.
then yes.
Right. So, right. So probably New York could have crafted an indictment where they didn't do that, but that's not what they did. And then on the preemption, we talked about this before. The federal judge ruled that the state case was not preempted by the federal law on election law on certain theories, and then the state of New York used a different theory for the trial. one that the federal judge might have found was preempted, right?
Yes, but they presented that argument to the judge that had denied the removal initially, and he skipped over it basically by saying, you're too late. You've already lost this once, and you don't get a second bite."
I know, but I'm
Whether
talking
I
about
was
the first time.
right, I've ruled. I sent it back to the district court in state court, and you don't get two bites at this apple.
Yeah, but I'm talking about the first bite. In the first bite, the federal judge said that the state of New York's case was not preempted by federal law, but that was based on the representations that the state prosecutors made about the theory that they were going to use. And
Correct, but
and
what I'm saying is when they removed it the second time,
yeah,
and they
but
made
wait,
that
wait, wait,
argument.
wait, 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 wait. But I'm trying to communicate to
Okay,
people that the federal judge said no preemption based on the theory that the state prosecutors laid out for him. And he said, okay, yeah, that's not preempted. And then when they took the case to trial, they used a different theory that the federal judge might have said was preempted. They changed their theory. And so they went on ahead, as everyone knows, Judge Marchand held the trial and Trump got convicted and blah, blah, blah. And now on this, King, what you're talking about, the second bite at the apple, the federal judge basically is just glossing by that, right? He's saying, second bite at the apple, I'm not going to help you.
that's right, and uh, but this 100-page pleading that I have not seen yet,
Yeah.
what does it do? Take that up to the
Yes. Yes. So
Federal
now they're
Court of
trying to
Appeals?
take it up. Yes, which is the Second Circuit, you guys. The New York courts are under the Second Circuit, obviously not the DC Circuit. Um, and so, yeah, so now they're trying to get the Second Circuit to say that the district judge got it wrong when he said no removal. I think just the second time, not the first time. I mean, Donald J. Trump is like full employment act for lawyers. King, what do you think?
Well, it's obvious. Uh,
Ah, you know what some of this stuff is kind of dry, right? Like I miss the days when we were talking about Fannie Willis's testimony. I laughed my whole way through that spaces that time. But we got to talk about removal, I guess. We got to talk about removal.
but from a broader perspective, part of Trump's problem is he has a what I think is a whole section of the bar who would not work for him under any circumstances
Yeah,
for political reasons
right.
and for
Business reasons.
business reasons, like other clients would get pissed off.
Right.
Uh, and then there's a subset, another set of lawyers who might have considered working for him, but who've been scared off
Right.
by the criminal prosecutions and
The
bar
lawfare against
complaints
lawyers. Right.
that his other lawyers have experienced.
Right.
You represent Trump. You're jumping into the fire.
Right. Yep. But I mean, he's got a lot of cases. He's got this case in the Second Circuit, right? Isn't he? And he's in the New York Court of Appeals on Letitia James's case. Marchand's sentencing is delayed until after the election. He's got this DC case with Smith in front of Chutkan, right? But he's in Florida. He's up in the circuit on Judge Cannon's dismissal. The Georgia case is in the state court and in the 11th Circuit, right? And is going to be in the Supreme Court as soon as Meadows' deadline comes up for filing on the removal. I mean, it's just, how many is that? Good
Did you
God.
did you mention Jean Carroll?
Oh, no. I mean, I'm just talking about the criminal cases, not even
Okay.
civil ones. Well, Letitia James is civil, but
Letitia
yeah,
James and Jean Carroll,
yeah,
he's got those appeals going.
right, exactly. So it's like that's a lot of litigation, a lot of litigation. All right. Well, so I think that's probably enough for tonight. We've been going for not quite 2 hours, a little bit shorter for us tonight than usual. We are, as you can see, keeping an eye on everything that's going on. And when some of these things get fully briefed in the DC case, then we're going to talk on a spaces about those in particular, like issue by issue, like we did before when the Supreme Court had this stuff pending. The Supreme Court is back in action now that October has arrived. And so there may be some things there that we could talk about. If folks want to talk about any particular Supreme Court case, send me, tweet at me or me and King and Ship about what's going on there. And if it's interesting, then we can take a look at those. The Supreme Court does interesting stuff every year, but so far this year, the docket doesn't look to me as spectacular as it did last year for right of center issues. Last year's docket was incredible. Um, so that's all I have for tonight. King, have you got anything to sign off with?
No, that's all I've got.